So, hello, I'm going to introduce a couple of concepts related to the fair use principles we're going to discuss. And I just want to point out there are some other paths to the same result as nominative fair use. So, for example, even though the Sixth Circuit has refused to adopt nominative fair use as a doctrine, it imposes a requirement that the defendant must be using a term in a trademark way. That's the standard trademark way, which seems to cover a fair amount of what other circuits would call nominative fair use. Some courts in the Sixth Circuit have held, for example, that referencing a trademark owner in comparative advertising does not count as use in a trademark way by the defendant, or have stretched the term descriptive to include uses that other courts would call nominative. And I'm going to make the case that that's not as ridiculous as it sounds if you just think about the statutory definition of descriptive fair use. Before New Kids, the First Circuit had also approached these issues in the Boston Marathon cases. And I'm just going to introduce a case that provides the background to the WCVB case in the casebook, Boston Athletic Association versus Sullivan. So these are some authorized T-shirts and other authorized merchandise. And the question presented in the first Boston Marathon case, which is Sullivan, is whether the public is likely to believe that the sponsor of the Boston Marathon produces, licenses, or otherwise endorses defendant's shirts. And I've recreated what's on the front of the defendant's shirt. So 1986 Marathon, a picture of a marathoner, and the words Hopkinton, Boston. The First Circuit found trademark infringement. It reasoned that the defendants were taking a free ride at the plaintiff's expense, citing INS versus AP. The plaintiffs didn't have to prove that members of the public will conclude that the defendant's product was officially sponsored by the marathon, because that would be a legal conclusion that ordinary people could have trouble with. Rather, in cases of intentional copying, the second comer is presumed to have intended confusing similarity and is presumed to have succeeded. So, 1, defendants intentionally referred to the Boston Marathon, and 2, purchasers were likely to buy the shirts precisely because of that reference, and it was therefore fair to presume that people were likely to be confused about source or sponsorship. The burden was on the defendant to rebut the resulting presumption of confusion. We will discuss the implications and scope of this principle in class. You can see from my description why the marathon thought that it could win its case against a TV station that broadcast the marathon without the marathon's permission. There was, in that case, an intentional reference, and people were clearly likely to watch because they were watching the marathon. So it sure looked like the presumption of confusion ought to be triggered. So we'll talk about that in class. But before I go, I want to mention 2 more issues that show the complexities that might arise here. First, uses that might be nominative or descriptive. If they might be both, can they be either? And this is not an uncommon advertising technique because it's clever. So we have this Baby Ruth ad, which disparages a competitor, but also uses the descriptive meaning of Snickers. Probably not descriptive fair use because it's not solely the descriptive meaning of Snickers, but maybe it can be nominative fair use. Similarly, we have this use of prime. So the lexical meaning seems to be the descriptive meaning of prime, but also you can see the clear reference to Amazon. So too, with frozen burgers, that's not a Happy Meal. Sorry for the poor quality of the picture. So the descriptive meaning of Happy Meal is there, but so is the reference to McDonald's. This one's a little different because it's not comparative in any way. It's just a play on the different potential meanings of Fuji. Where it gets interesting, I think, is cases like the Rock and Roll Hall of Fame. So consider this poster. Could you call this descriptive fair use? Is it describing something that only happens to be a trademark also, at least according to the plaintiff? So this is the kind of case that the Sixth Circuit thinks maybe we can call that descriptive fair use, even if there's also a trademark reference sort of in there. Or would you rather call this nominative fair use, or both? So the final topic then in the video is comparative advertising. One possibility is to consider comparative advertising a kind of nominative fair use. Other countries highly disfavor comparative advertising. For example, the European Directive on Comparative Advertising makes it extremely difficult to engage in comparative advertising. Among other things, Europe requires that the advertising has to compare material and relevant features. The comparison also has to be objective. So things like Pepsi tastes better than Coke would not be lawful. Also, you can't take unfair advantage of a competitor's trademark. And the comparative advertising can't claim that one product is an imitation or replica of another. By contrast, the US tolerates everything in comparative advertising unless it's false or misleading. There is really only one argument for the US position, which is comparative advertising encourages competition and helps consumers unless it is false or misleading. Notably, the reasoning in Smith versus Chanel seems to fundamentally distrust trademarks as signals of status. That is, if people derive value from knowing that they're really wearing Chanel and that other people can't, and having that fragrance be exclusive to Chanel, that's a preference that some, though not all, economists would tell us to honor. So you can compare the reasoning in Smith to master crafters or automotive gold and similar cases about when it's okay for a trademark owner to appropriate the cachet of its mark for itself. And Smith sets out a fairly standard principle that when the cachet is appropriated by means of comparative advertising, at least when the comparison is successful, consumers understand that what's going on is that a comparison is being made. That's okay. That's an okay kind of appropriation. The court says using the trademark of the copied product is the best and perhaps the only way to inform consumers of what the copier has for sale. So you can see why we could call this nominative fair use and just reduce comparative advertising to a subset of nominative fair use. We will test the limits of this principle in class as well, and I will see you then. Thank you.